Hi, everyone. My name is Jason Hanford. I'm an attorney at Chartwell Law. Today, we're taking a video with two of my partners. It's the latest in what has become a series of videos where we're taking information that we typically put into long form articles, and we're just shooting a brief video to discuss what we might have already put in the articles or what we might put in the articles if we wrote them. As I've mentioned in the prior videos, if you have any questions about these topics, feel free to put your questions in the comments. You can also reach out to us, send us an email. You can share the videos on your social media, share them with your friends or your coworkers by email. If you have any feedback, feel free to put it in the comments. If you have funny comments about what we're doing, or you like it or you dislike it, let us know. If you have any questions that you don't want to put in the comments on a social media website, you can certainly go to chartwelllaw.com and look each of us up. Our information is probably included somewhere in this video as well. You can shoot us an email or call us. We do hope that everybody's doing well. We recognize that it's an unprecedented time right now, but we hope everybody's staying safe and healthy. And as I have done for all of these videos, I want to remind you that the discussion that we're going to have, while it's interesting and hopefully helpful, it's not legal advice per se. So if you have any legal questions for us, we would encourage you to reach out to us directly. So without anything else, I'm going to introduce my partners. First, I'll introduce Brittany Atkinson from New Jersey. Brittany, can you say hi to everybody?
Good morning, everybody. My name is Brittany Atkinson, as Jason just said. I'm in our New Jersey office, and I'm here to discuss anything that has to do with New Jersey that you asked me to.
Awesome. And if you did already, Brittany did a video with me a couple weeks ago on COVID-19 in New Jersey and how it impacts workers' comp claims there. So certainly go back and look at that. Also with me today is our friend Lee Fiederer, our Philadelphia office. Lee, can you say hi to everybody?
Hello, everyone. Hope everyone's feeling healthy and well, tolerating working at home.
All right. Well, it's good to have you both on. We've got three people now, which makes it a little bit more exciting. It doesn't allow me to talk as much, but I think it'll give a little bit more content to people. So what we're talking about today is we've been spending a lot of time on coronavirus and COVID-19, and that's obviously the hot topic of the minute and for many minutes to come. But we also always want to be forward looking. And one of the things that our clients have been talking to us about, one of the things that we're thinking about a lot is what's going to happen next and what's going to happen after. And one of the things that I think we're seeing, and I think we're going to continue to see, is that as the situation unfolds where people are being told you can't go into work, if you can work, you need to work from home, people are doing just that. And we're seeing a lot of the workforce transition to a home environment where they're doing what they used to do in the office from their house, akin to what I'm doing here, to what Brittany's doing, to what Lee's doing. We're in our houses and we're working from home. And if you look at the federal recovery plan that was put out, the 3-phase recovery plan, I think at least the first 2 phases asked employers to have their employees work from home whenever possible. So it's very likely that even after this virus has passed and we've moved on to hopefully a happier and better phase of life for everyone, you're going to have a lot more people from your workforce working from home, probably on a permanent basis. So what do we want to talk about today? We want to talk about that topic. We want to talk about how to be forward thinking, how to anticipate with regard to work injuries in Pennsylvania and New Jersey. What are you going to be faced with a home worker, somebody who's working out of their house? So I guess I'll start with Lee for this. Lee, in Pennsylvania, does the Pennsylvania Workers' Compensation Act anticipate this? I know it was written in probably 1915. Does it anticipate somebody working telecommuting from home? Are there any specific provisions that apply? How does Pennsylvania deal with work from home injuries?
So the short answer, Jason, is work injury sustained at home can certainly be compensable. The Act doesn't speak to it specifically, but in a general way. The way the Act talks about it is within the context of a course and scope analysis. In other words, when an employee is injured on or off the premises of the employer and is engaged in furthering the employer's business interests, the injury can be compensable. So I really doubt in 1915 or even 1972 or even 1996, when the Act was amended again broadly, that the legislature contemplated people working from home in the context of how we're doing it now, on computers, sitting at our desks at home. But the Act did contemplate work injuries happening off the premises, which further the employer's business interests. So to elaborate really briefly, and then I'm sure Brittany will want to talk about how this works in New Jersey, in 2006, the Commonwealth Court of Pennsylvania was faced with the issue in a case involving Verizon. And in the Verizon case, it was pretty simple and something we could very much imagine might happen nowadays. In the Verizon case, the claimant had a home office in her basement that she was using with the employer's permission. She was working from home. It's already 2006. So she went upstairs to get a drink. And on the way back downstairs to her basement where her workstation was, she tripped and fell and sustained an injury. The question was whether the injury was in the course and scope of employment. The side nuance is that in Pennsylvania, we have a doctrine of personal comfort where if you temporarily depart from your workplace to attend to a personal comfort need, such as getting a drink or using the restroom, you're still within the course and scope of your employment. The further analysis in the Verizon case, real briefly, was whether or not her working at home was a compensable work injury. And the court said indeed it was, that she was working off the employer's premises, but with their knowledge and furthering their interests. And so, since 2006, there's been no question. In Pennsylvania, a work injury sustained at home, as long as it's furthering the employer's business interests, can be compensable. I don't want to take up too much time right now. I want to come back and discuss the burden of proof, but Jason, I'll pitch it right back to you.
Yeah, thanks, Lee. It sounds like that's something that's, of course, contemplated by Pennsylvania law. I was trying to be breaking news-ish and look up on Google while Lee was speaking when the New Jersey Workers' Compensation Act was passed. And lo and behold, I'm not very good at Google, and I have no idea, so I won't put Brittany to the test on that. But Brittany, as a general proposition, work from home work injuries in New Jersey, are they compensable? Are they possible?
So just as Lee said, it really depends. And really, in order to determine whether a work injury at home is compensable is a very similar analysis in determining whether any work injury is really compensable. Does it occur within the course and scope of employment? And additionally, in New Jersey, what we're really going to look to is whether or not the employee is reasonably fulfilling the duties of employment. So very similar to Pennsylvania, whether or not they're furthering the interests of the employer, or whether it's something incidental to the employment. And there's really no specific case law, which I'll touch on in a bit, for work from home injuries, but I'll talk about it in a little bit for everyone. But there's a lot of off-premise case law. So we can talk about that and sort of tie that into working from home, as it is very similar.
Okay, so workers, don't fear if you're injured at home. It sounds like that both Pennsylvania and New Jersey contemplate to some extent that happening. Lee, you had mentioned burden of proof. What are you looking at in Pennsylvania as far as burden of proof for a work at home injury?
So assuming that we have someone who believes that they were injured at home, furthering their employer's business interests, it's still the same burden of proof. Like Brittany was saying, it's still the same burden of proof issue, and it's still going to be the claimant's burden of proof. So Jason, I wanted to illustrate a case decided in 2011. It's a fairly horrific set of facts, but it illustrates how hard it can be to show a claimant has met their burden of proof. Donald Werner sustained a brain hemorrhage at home. It seems that that's what had happened, according to all the medical records, and that he had been working from home for some time with his employer's permission in a home office type setting. But the court very clearly put the burden on Donald Werner's widow to show that the injury happened while he was working, where it happened, how it happened, etc. And through an extensive forensic analysis, something like you might see on TV, something you might see in a 2-hour TV drama, it was not clear whether the claimant was actually working at the time that he sustained his hemorrhage. It wasn't clear whether he had been hit by someone else or perhaps fallen himself. Some of the evidence seemed to suggest, and the judge seemed to buy into this idea, that perhaps he had gone to retrieve his personal mail, or that he was smoking a cigarette outside, and that it had gone beyond the personal comfort doctrine we had just previously discussed a little bit. And in this particular case, because the claimant retains the burden of proof, and in this case, his widow retained the burden of proof on a fatal claim, the judge found that the claimant could not show that at the time of his death he was in the course and scope of his employment. They went so far as to analyze his emails and to show that he had been sending work emails until about 1 in the afternoon, but then seemed to take a break from sending work emails, and that the death had probably happened after that period of time. So even though employers are going to face a tough time disputing a factual allegation that a work injury happened at home. We need to keep in mind that it's still going to be claimant's burden of proof that the accident happened during the course and scope of employment when the accident happens at home.
Lee, that was just for the viewers' information of my own. That was there wasn't a slip and fall or anything that caused the brain hemorrhage in that case. It just happened.
Jason, it's a very hard case to carve out the facts, and I think that it might have been very fact specific on the medicine. It seems as though there was a trail of blood coming from outside into the house, that he may have broken his glasses at some point outside the house. So it really turns on a specific set of facts. But the point I want to illustrate here is that just because an accident happens at home, something may be very hard for our clients to dispute factually. I mean, after all, we're not going to have video of the accident scene if it happened at the claimant's home, as opposed to, let's say, a manufacturing facility where there might actually be video of what happened. It's still going to be claimant's burden of proof, and the cases can still be defensible, even on the facts.
Yeah, it's interesting. I think we'll talk about it in a few minutes, but it opens the door to potential issues with heart attacks, with strokes. One thing I want to talk about later is it brings into question work hours, because if your employee is not working necessarily an 8 a.m. to 5 p.m. shift, and they're allowed to work whenever they want to, then that really opens up the door to, well, did this happen, whenever they wanted to work. But before we move on to that, and thank you for that, Lee.
Yes.
You had talked about case law in New Jersey about, I think, off-premises cases and how that informs a work-at-home injury. Could you tell people a little bit more about that?
Yeah, so like I said earlier, we don't really have too much case law specific to work from home injuries, but we have what would really cover it and really set the analysis up for it are these off-premise cases. And the leading case law on this is Jump versus City of Ventnor. And in that case, the employee was a pumping station inspector. So he was going from one inspection site to another throughout the city all day, every day. So it was reasonably expected for him to stop for, coffee or for lunch. But everything he did was off premises. But on the date of the injury, he actually stopped along his route, which was on his way to the next inspection site, to pick up his own personal mail from a local post office. And the Supreme Court found that this was actually a major deviation as opposed to a minor deviation, and that it was not compensable. And they really differentiated between what was a personal errand and what was something incidental to the employment that was actually furthering the employment of the employer. And the Supreme Court said in that case that the employee must be in their direct performance of duties. And here, they didn't find that. They found that, this was not something that can reasonably be expected on the part of the employee to stop and get his mail. But we take that with a grain of salt, because there are a ton of cases in which the details of the accident and how it really occurred would seem outside the scope of employment. And one of the cases that really jumps out of me is Cooper versus Barnacle Enterprises. And here, the employee suffered injuries during a motor vehicle accident. He was at the union hall for a meeting with his employer to find out his next job site and the details of his next job. He learned that the meeting was being delayed, so he left the union hall and drove 5 miles down the road to get a cup of coffee. And on his way back, he was involved in a motor vehicle accident. The court in that case found that it was reasonably expected for him to leave the meeting, go get a cup of coffee, drive 5 miles, and sustain the injury, and that was compensable. So it's really not that much different than, the first case I was talking about, where the employee was leaving, or employee stopped to pick up some mail. So it's going to be very fact specific, and it will really depend on whether or not that is some sort of behavior that can really expected on the part of the employee.
It must have been really good coffee too. It's a persuasive factor for the judges. It's interesting that you bring up how fact specific it is, because one of the other things we do at Chartwell is we do workplace injury management, I guess consulting. Well, we'll go out and talk to employers about, how their workplace is set up from a workers' compensation defense attorney perspective, what might be concerning, that sort of thing. And guys, I'll try to pick one of you so we're not all talking at the same time. But one of the first things I think about when I'm thinking about work from home injuries is loss of control for the employer, because in the workplace, the employer gets to dictate, you start at this time, you stop at that time, dictate safety equipment, dictate ergonomic equipment. This is where your keyboard is. Brittany, I'll start with you. I don't think we can start putting surveillance cameras in people's living rooms or their offices at home. What do you think in New Jersey employers are going to want to be mindful of when they have more of a home-based workplace?
So one of the things I did think about was what you said earlier, limiting time. So, requiring employees to work from 9 to 5. But in New Jersey, we're sort of talking about this reasonableness standard. If it is reasonable for certain employees to work at night because perhaps they have kids during the day that they're watching, especially during this climate right now with everybody sort of being in the house and it being difficult and distracting to work between 9 and 5. If it's reasonably expected for a certain employee to work at 9 o'clock at night, as you were talking about, then it could very well be found to be a compensable accident if they do sustain the injury and can prove somehow that they were working during that time. Another thing that I really thought about is sort of limiting the workspace. So sort of requiring an employee to have a designated workspace so that you're not opening up the doors to the steps or a different area of the house. But again, we're talking about a reasonableness standard. So if the person sustains the injury when they're going to the bathroom out of their designated workspace, then that's probably going to be found to be compensable. But so this morning I left my designated workspace as something was cooking on the stove, and I was making gravy. And so I kept getting up from my computer to go stir the gravy, and I call it gravy, not sauce, everybody.
I was going to question, are you making pasta or turkey? What are we going for?
I was making meatballs and spaghetti. So every so often I got up from my desk to go stir the gravy. If I had burned myself during that time, that's probably not compensable. But again, is it reasonably expected that I could be cooking during the day as I have, a family here, or, while I'm trying to prepare for my day, really? So it's really will be fact specific.
Yeah. And
Jason, can I just chime in for 1 second? Because I was so taken with Brittany's story about her gravy.
I saw you feverishly writing notes. I didn't know.
So here's my question. Here's my question for Brittany. This is actually a legal question. Brittany, I agree with your analysis, by the way. If you get up to solely stir the gravy, you have so far departed from work that it's probably not compensable. But what if you go to the refrigerator to get a drink as part of your personal comfort doctrine, which I think applies in Jersey just like it might in Pennsylvania? You got up to the refrigerator to get a drink, like the claimant in the Verizon case, and on the way back, you accidentally hit the pot containing the hot gravy and burned yourself. You only got up to get the drink. You have a no-fault situation just like we do in Pennsylvania. Brittany, I have a question. Would your burn from the gravy, not that that should ever happen to you, would that be compensable under the personal comfort doctrine when it happened when you were getting the drink in the first place?
So when you say personal comfort doctrine, we sort of have a similar term. We would call that sort of a minor deviation.
Right.
I do think that could be considered compensable, considering my intent was to go over to get a drink, and on my way back, I knocked it over accidentally. I mean, we have a no-fault system just as in Pennsylvania. So that could be considered to be a minor deviation in New Jersey, and as a result, compensable.
Jason, sorry to interrupt you, but I was really curious about how Brittany might answer the gravy drink question.
I was going to say, I thought I was the questions guy. I was getting here. What were you taking? Were you taking notes on something else, Lee? I guess the question I would have as an employer is, okay, that sounds really scary. What do I do about it? Do I put this in the employee handbook? Do I send out a firm-wide email? What do I do as an employer to try to get out ahead of this?
So I want to agree with a lot of what Brittany said and then address a couple side issues as well, because I did make notes there. I agree with the idea that when it comes to hourly or hourly employees, as opposed to professional employees or salaried employees, those hourly employees should probably be locked into designated work times and should have to log in and log out. I think most employers now have the ability to have a worker who is logging into a computer start their day with the login time and end their day with a log out time, just like an old punch the clock situation there. So I'm approving of that. It's going to be a lot harder when someone's a professional employee, let's say a lawyer or someone at a management level, to lock them into certain hours, because you don't really lock them into regular hours during the rest of the year. So it's, and they don't work 40-hour weeks. A lot of these professional people work a lot more than 40 hours a week. So how are you going to lock them into a set number of hours? I'm not sure that's going to fly for some of the workforce, but for the other part of the workforce, yeah, I think it's a really good idea. The designated workspace at home is probably going to be a challenge. Are our employers going to send out ergonomic consultants and traipse through people's houses saying you can work in this room but not that room, or you shouldn't log on with your feet up at your coffee table and start sending emails in your bathrobe? I don't, as opposed to working, let's say, in a home office or a sunroom. So I think that's going to be a harder challenge in terms of locking someone into a home-based designated workspace. And I just think it's going to be difficult,
Yeah, and I think for employers that there's a cost added to that. You got to send somebody out to. Hopefully, there's a cost savings if more people working at home. You're not paying the rent that you used to. But I think what we're really talking about here, especially with professional employees, but maybe with a lot of employees, is you're not only expanding the potential work day if somebody's answering emails at, you get up at night to answer an email at 2:00 in the morning and you fall down the steps.
Yeah.
That's not something we typically have in the office, unless people are really working late at the office. But you're also expanding, as Lee mentioned, the workspace. You'd like to think that everybody's working, discreetly tucked away in a small corner of their house, but that's not always the case. Maybe it's a nice day out and they want to sit outside and a tree falls on them or something terrible. They get attacked by a dog. We could get silly with it, but I think it really expands the potentials. And again, I think the employers I know, they don't like uncertainty and they don't like lack of control. And I think those are the concerns here. Did you guys have any other thoughts on what we could do from the employer's perspective?
Jason, I'll just chime in a little bit. I agree with the idea of ergonomic workspaces in general. It's going to be a lot harder at home. I don't know of employers who are facing the current situation we have now, where all of a sudden so many people are now working from home. I don't know of employers who have been able to accommodate ergonomic needs. I personally don't enjoy working on a laptop. I prefer a workstation. And my employer would have to really send someone out to my house to make sure that it was all ergonomically set up. And I'm not expecting most employers to be able to do that. So that's also a situation. And employers really are going to have to be careful about how closely they scrutinize what someone is doing in their own home. Avoiding the creepy issue, we have the legal issues. I mean, how much can an employer really do in terms of monitoring what the employee is doing in their own house? It's not like you can walk by someone's workstation in the office where I'm in our Philadelphia office and see whether someone's working or chatting on the phone. I don't think we're going to have that level of employer surveillance on home-based employees.
Yeah. And I think one other thing that I'm thinking of as you're talking is if we get to a claim petition stage, and at least in Pennsylvania, if it's a disputed claim, we're not going to have what we sometimes look for great help, which is fact witnesses, coworkers, people in the house. I don't think in most instances, depending on how life is going, your spouse is going to testify against you in a workers' compensation proceeding. My kids probably would testify against me, but they're pretty young, so they're probably not that credible. So there's anything that you can think of, Brittany, from that perspective in New Jersey when you're actually litigating a claim, how it would make it harder, or maybe it would make it easier for you?
It would definitely, for the employer, make things, it makes things a lot more difficult because, like you just said, there's no witnesses. There's nobody to dispute that when you were walking down the steps at 2 a.m., you weren't answering emails. There's nobody to dispute, the gravy incident. I wasn't just going to get a, drink of water and accidentally hit the gravy pot. So it's definitely going to be much more difficult for us to dispute claims and sort of prove that they didn't happen during the course of scope of employment.
Yeah. So we don't want to be gloom and doom. I mean, there's obviously positives to having a workforce that's not out. There's not going to be as much driving around for these workers. They're not going to be getting as many, hopefully, auto accidents. They're not going to be hopefully slipping and falling in the parking lot or at the stairs to the building. You're going to have those whose property was it on kind of things for these employees in particular. So, there's obviously going to be things that are more in our favor, but we do like to point out that, this is what you're going to be faced with a work from home workforce, and the workforce goes through transitions. We're more of a service industry now than we were 100 years ago, obviously, when the Pennsylvania Act was written and whenever the New Jersey Act was written. The economy and jobs have changed in general. So we're gonna continue to do that, and this is probably the next step. Any other comments or thoughts from you guys before we try to wrap it up?
Jason, I'm ready to wrap up. I think that you've really covered everything regarding course and scope, compensability of injuries which happen at home, and what employers might look to mitigate claims through making sure people are working at designated times and things like that. I think you did a great job. And
Brittany, anything from you?
Jason, you did a wonderful job again. I'm happy to be here, and I hope everybody is just staying healthy and safe. Yeah,
this was a fun one. I think maybe we can call it the great meatball video of 2020. We'll throw Brittany's recipe on the end, and we've cleared up what the correct usage of gravy is. So if you have angry comments, put those on our social media. But hopefully we've opened your mind a little bit. If you have any questions on this, please do reach out. We part of our job are the hypothetical questions that we're concerned aren't so hypothetical, and it might have been something that just happened, and you're looking for some first thoughts on that. And we get that all the time. We're happy to talk about that, but we're also happy to talk about stuff like this where you're concerned about what's going to happen in the next 6 months. So we do hope everybody's doing well. We hope you enjoyed the video. We thank the people that made it through, and we'll be back again soon, and we'll be talking about this and other topics that we think our clients might be interested in. So thank you, everybody. Take care.